I've started a podcast about civil litigation, but I still get to talk about the Karen Reed case. Hallelujah. There are multiple lawsuits and possibly more to come, and parties fundraising to boot. I want to set the stage for the proceedings that are going to last for a little while here. May it please the audience, I'm Rich Schoenstein, and this is So Sue Me, the podcast about civil litigation, and the Karen Reed case is in civil litigation now. There are 2 lawsuits and possibly more to come. Because I don't know who the audience is for this thing, I got to give a little bit of a refresher about the Karen Reed case. And if you've heard this a million times, you can fast forward to the next chapter, or you can go ahead if you're listening a couple of minutes. But for the uninitiated, the Karen Reed case emanates out of Massachusetts. Officer John O'Keefe, a Massachusetts police officer, was found wounded, it turns out fatally wounded, on the front lawn of a piece of property in the early morning hours after a very serious snowstorm. He was found unconscious in the snow with a pretty bad head injury, and he died from that. His girlfriend, Karen Reed, who had driven to that house with him. They had been out drinking with a bunch of people the night before. There was a move for those people who had been at a couple of bars to go to this house. I'll tell you more about that in a minute. Karen Reed and John O'Keefe drove over there. Karen Reed was arrested. She was charged with his murder, and the case went to trial. And there are 2 competing theories. The prosecution has asserted that Karen Reed backed her SUV into O'Keefe sometime after midnight, left him to die alone in the snow, and they point to evidence such as pieces of broken taillight that were found at the scene and certain statements of Karen Reed that were made and her behavior, which we could get into, but we're not going to do it right now. The defense says John O'Keefe was likely killed inside the house and then dumped on the lawn. Now, the people inside the house were other people who worked in Massachusetts law enforcement and had been out drinking with O'Keefe and Reed and others the night before, and some family members. And there's a conspiracy theory on the defense side that law enforcement engaged in a conspiracy and cover-up. And they also question the sufficiency of the evidence against Karen Reed, including notably whether or not there was even good enough forensic evidence that O'Keefe was hit by a car. Whether or not you believe in conspiracy, there was definitely troubling conduct by law enforcement. There was one officer in particular who had some very damaging texts that appeared to have him. There was one officer in particular who appeared to jump to conclusions right away and had some very damaging, arguably biased texts against Ms. Reed, and that was a big point of the trial. The public is very divided about this case. There are many out there who believe she is guilty, obviously guilty anyway, but there's also a strong movement. It's been known as the Free Karen Reed movement that believes the opposite, that believes she was set up, that she is the victim of Massachusetts police, that this emanates from problems with the police in Massachusetts. And so there are 2 warring factions on opposite sides of this case. The case went to trial. The first trial ended up in a mistrial. The jury could not agree on a decision. So a year later, they had a second trial. The second trial led to a not guilty verdict, a unanimous not guilty verdict by the 12-person jury on 2 of the counts, and a guilty verdict only of OUI, operating her vehicle under the influence. But as to the murder charge, the manslaughter charges, she was found innocent. Now, at the second trial, the defense downplayed the conspiracy angle and focused more on a lack of proof beyond a reasonable doubt, challenging that forensic evidence I mentioned and other evidence, and apparently convinced the jury there was not enough evidence to convict Karen Reed. Now, let me be clear about this. I'm just here to analyze this case. I'm not working with either side. I'm not working for either side. I never have. I've never taken a side in this case. I've not joined the Free Karen Reed movement. I've also not stood by the prosecution. I have been critical of both sides throughout the first trial and the second trial where I thought they deserved criticism. And I have drawn the ire on occasion from both sides, but so be it. Now, after all the criminal prosecutions are over, we have civil litigation, and there are 2 civil lawsuits that have been filed. The first civil suit was filed before the conclusion of the second trial by Paul O'Keefe, that's John O'Keefe's brother, the estate of John O'Keefe, and then some other O'Keefes against 2 bars, McCarthy's and the Waterfall. Those are the 2 bars that the people were drinking at, including O'Keefe and Karen Reed, before the accident. And Karen Reed, those are the defendants. And this is what I would loosely call a wrongful death action against the bars for allegedly serving too much alcohol. You'll see wrongful death against C.F. McCarthy's as the first count, against Waterfall Bar as the second count, and then against Karen Reed, wrongful death is the third count. And that is basically the count charging her with causing the death of John O'Keefe. And then there are claims for negligent infliction of emotional distress, again against C.F. McCarthy's, also negligent infliction of emotional distress. And these are by individual plaintiffs, right? There's one different one for each of the individual plaintiffs. And then counts against the Waterfall by the individual plaintiffs as well, and then counts against Karen Reed for negligent or reckless infliction of emotional distress. Those have somewhat to do with the way Karen Reed defended herself in the case, as well as, obviously, from allegedly causing the death of John O'Keefe. Now, the second action was filed on November 17th, and you'll see in this one, filed in a different superior court. We have the wrongful death action is pending in Plymouth, and now we have this other action by Karen Reed pending in Bristol. And this is against Michael Proctor, Yuri Buchanan, Brian Tully. Those are police officers that were involved in investigating the crime. And then Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. Those were people who were inside the house. The house was owned by Brian and Nicole Albert. Brian Albert is a police officer. Brian Higgins is a police officer. Jennifer McCabe and Matthew McCabe were also there. I'm not going to go through all the allegations of the complaint. These are pleadings. They are just allegations. Nothing has been proven yet in this case. But obviously what Karen Reed alleges is that John O'Keefe was really killed inside that house, and then everybody involved concocted some sort of conspiracy against her. All right, so the causes of action in Karen Reed's case, they start with a statutory malicious prosecution cause of action against the law enforcement defendants. That's what I'll call them, Proctor, Buchanan, and Tully, for allegedly violating her rights. There's one under statute, and then there's a supervisor liability claim against Buchanan and Tully for responsibility, including for things that Proctor did. Then there's a cause of action against all the defendants, the law enforcement defendants and the House defendants, for conspiracy to deprive Ms. Reed of her Fourth Amendment rights. And so you have that cause of action. There's a similar cause of action under Massachusetts Civil Rights Act. That is a Massachusetts statutory cause of action. And then there's a common law malicious prosecution cause of action, essentially alleging that they picked out Karen Reed to be the scapegoat and prosecuted her to get all these other people off the hook. There's an intentional infliction of emotional distress cause of action, so everybody involved is claiming an emotional distress. There's a civil conspiracy cause of action. And that's what's been alleged. It is a very well-written, it's a very persuasive cause of action. You'll see that Karen Reed has local Massachusetts counsel, but she also has Alan Jackson, the high-profile trial lawyer who successfully represented her in the criminal case. So he is very much involved in this. Now, another lawsuit may be on the way. The House parties have said that they're going to sue for defamation. They're going to bring claims against her and possibly others for accusing them of murdering John O'Keefe and or covering up the murder of John O'Keefe. I don't know if that's actually going to happen. There's been talk of it. We haven't seen it yet. They could do it in an independent action. We could have a third action. Or they could assert those claims in one of these other cases. For example, they could assert them as counterclaims in the case that Karen Reed brought. We don't know yet which they're going to do. Now, this is really interesting, to me at least. Both sides appear to be fundraising. The House defendants recently launched a site for contributions, and Karen Reed is also asking for support for her expenses. So here we have a site on Pay It Too, which is a crowdsourcing, a fundraising site for the Karen Reed civil case. It says it's raised $3,500 as of the time of this recording, and you can click here and donate. A website called defendingthetruth.org has been launched, purportedly on behalf of the witnesses, what they're calling the witnesses in the Karen Reed trial. This website talks about how the witnesses have been harassed and defamed, and now they want to defend themselves, and you can take action by donating to them. There's a lot of information here about the mission and the vision, and some of it is specific about the Alberts, the McCabe's, and the Higgins family, and some of it's more general about the rights of witnesses and the rights of victims in these kind of cases. We saw an announcement today that the Testify people are going to have an online event on November 29th, Saturday at 7 p.m., where they're going to go over developments in the civil suit and special, exciting plans they have for the future. We've seen on the internet some taking up the cause of Karen Reed. Karen Reed needs financial support for her civil suit. She's lost everything. And you'll see this post asks supporters simply to Venmo her and give their support. Turtle Boy had an interesting reaction to this. As you may know, if you're following this case, he's a little bit on the outs with Karen Reed. And he says, just to be clear, Karen Reed has a very substantial offer in front of her if she needs cash. And he mentions being invited to do something, and then gets into the fact that she's not facing any criminal charges anymore like he is. Turtle Boy has had some things to say about this fundraising effort. So both sides in this case are seeking monetary support for civil litigation, which I think is just absolutely wild. And if I was going to donate to either side, I personally would have some fundamental questions. And again, these would be for either side. The first thing is, I would want some financial disclosure. I think I would want to understand more specifically why it is there's financial need. I mean, I know litigation is very expensive. I know attorneys are very expensive. I'm expensive by way of example. But I don't know that these people have special need for funds. They seem to be living pretty well-off, comfortable existences as far as we could tell. I would want to see some financial disclosure. I would also want to know exactly what is the money going to. What can the money be used for? Only for litigation purposes? Or can they use it, for example, for household expenses? Can they use it for a vacation? If you Venmo somebody money, presumably they can do anything they want with it. But also, if you give to a crowdsourcing effort, you don't have any right to get your money back if they do something with it that you don't like. So are they paying for expert witnesses or floor cleaner or both? What are the financial circumstances? Karen Reed says her funds have been depleted, but as Turtle Boy notes, she has avenues of making money, potential book deals, potential media deals, potential appearances. There may be opportunities for her to make money, and I would question whether financial support is really necessary or appropriate. So this kind of crowdsourcing for litigation is not a totally new phenomenon, but it's much easier now with social media and with apps and websites that allow you to set up crowdfunding and fundraising activities. We've seen it recently with Luigi Mangione, who has raised a ton of money for his defense, and he's accused of murdering a guy in the middle of the street by shooting him in the back. So there are people who will give to almost anything. Litigation is expensive, and I'm sure that these people are stressed. But to me, I would want to know a lot of information about the specifics. And also, I might think about where else my money could go to, because there are a lot of people in the U.S. criminal justice system who do not have the resources for a lawyer. There are a lot of people who would like to litigate civil cases but do not have the resources for a lawyer. I'm going to talk about contingency cases in one of my upcoming episodes and explain why those are super hard to do in the civil context. So if your point is you want to be able to help folks who have to defend themselves in court and have every right to defend themselves in court, but don't have the agency or the finances to do that, maybe you could find a better avenue than the parties in these cases who are in it to get big financial judgments on their behalf and who may have other sources of income. I'm just saying you should think before you give. So the Karen Reed case, the first Karen Reed case, the case against her had a hearing last week on November 21. It was done on Zoom, but they cut off after a certain number of participants. If you looked around on YouTube, you were able to find it. You were able to live stream it. It's no biggie either way. I'm a huge advocate of cameras in the court, but there's very few civil cases where you have cameras in preliminary hearings and discovery conferences. I mean, those are kind of mundane. It's not like people are testifying in them, so it doesn't bother me if they're not big public spectacle. But obviously, if people can get their cameras in this case, they're going to. It sounds like, from what the judge was saying, that the first two cases are going to be consolidated for pre-trial purposes. And what that means essentially is they'll share discovery. They'll use the same depositions. They'll use the same document production. You won't have to do it two different times in two different cases. That makes sense for everybody involved, including the court. It's judicially efficient. It's efficient for the parties. You get to trial, however, no decision has been made. So you could still have separate trials of the claim against Karen Reed for wrongful death and Karen Reed's claim for malicious prosecution. It might be more efficient to try everything together because one case is sort of the flip side of the other. And then if you add in defamation claims, you're going to have yet another flip side. And all of those facts rely on the central question: did Karen Reed kill John O'Keefe or not? And some of you may wonder why that's still an issue. Didn't we already have a trial? Didn't we have two trials? One where the jury couldn't decide and one where the jury said not guilty. So this gets us into why civil litigation is fundamentally different from criminal proceedings. In civil litigation, it's a totally different burden of proof. In the criminal cases, the prosecution had the burden of proving guilt beyond a reasonable doubt, a very high standard, to get a unanimous jury. In a civil case, the burden of proof is only more likely than not, or what we call a preponderance of the evidence. 50.0000001% more likely than the opposite. And because it's a different burden of proof, the fact that Karen Reed was acquitted in the criminal case is of no moment. If she had been convicted, that would have been relevant for the civil case, but her acquittal is not. It won't even be evidence. It's not going to come in. They're not even going to tell the jury, although good luck finding a jury that hasn't heard of Karen Reed. Now, the other main difference in a civil case is everyone testifies. Karen Reed will be deposed if these cases go forward. She will be sworn to tell the truth. Her deposition will be taken by multiple lawyers representing multiple parties, and all of these other witnesses will be questioned again as well. The McCabe's, the Alberts, Brian Higgins, the law enforcement parties, and all the other witnesses we saw in the first trial. Everybody testifies. I said the acquittal is not evidence. The OUI conviction is potentially evidence against Karen Reed, but I think she's going to argue that the fact that she was found to have been drinking that night and operating a car over the limit doesn't prove she killed anybody, and it's too prejudicial. So I'm not sure that's coming in. Maybe it could. Remember, when you're looking at these complaints, allegations are not evidence. I heard everybody talking about a bombshell complaint. There's no such thing as a bombshell complaint. Complaints are words. Complaints are lawyers drafting, and it's a good complaint, like it's well written, but it's not a bombshell. It doesn't prove anything. It doesn't cause anything to happen other than a lawsuit. Next point. This is going to take a very long time. Civil cases, a really long time, especially when you're talking about multiple cases that maybe are getting merged together. You get motions to dismiss, then you get discovery, then you get more motions, and then only if you get past all of that do you get to trial. We may see new evidence. The criminal trial is very controlled, and criminal trial judges really limit the evidence. And I know that Judge Cannone made a lot of rulings that frustrated the defense, and she made rulings that frustrated the prosecution. And in a civil proceeding, the evidence is a little more wide open. I mean, they still bar evidence if its prejudice outweighs its probative value, but they're not anywhere near as careful as in a civil case. Undoubtedly, you will see more evidence. You will probably see new expert witnesses. I didn't think that any of the expert witnesses in the criminal proceedings were very compelling. Don't get me started on the ARCA guy. I know a lot of you guys love the ARCA people. I wasn't so moved. I would expect new experts, certainly new experts, for the people on opposite Karen Reed. They're civil cases, so they can settle at any time. You can have partial settlements. The bars could agree to pay her some sum of money to be left out of the lawsuit, by way of example. Individual defendants could settle. In civil litigation, there's always a possibility of seeing alliances fracture. For example, so far, the House defendants and the law enforcement defendants have acted pretty much in lockstep, but if push comes to shove, are the House defendants unhappy with the law enforcement defendants and the way they handled the case? If the House defendants are really innocent, do they think maybe if the law enforcement defendants had done a better job, the case would have come out differently? That's an alliance that could fracture. Or if someone in that House were really guilty, then the relationships between the House defendants could fracture. On the other side, we're already seeing a fracture between Karen Reed and Turtle Boy, who has been one of her principal stalwart supporters from the beginning. They seem to be on the out. Whether that's going to be relevant to any of the proceedings, I don't know. There's been speculation that he might be a defendant too in the defamation case, if there is a defamation case, but I don't know. We haven't seen it yet. I think the big overwhelming question here is, why litigate at all? It seems that the O'Keefe family, taken at their word, wants justice for what they believe happened. That's the only reason I can imagine that they would want to go through this again, because there may not be an incredible amount of money to be had in suing Karen Reed, especially if you win and get a jury to say that she's the person who murdered John O'Keefe. I'm not sure that that gets you a lot of money. I think that's part of why the bars are in the case, but the claims against the bars aren't very strong. What is Karen Reed doing? She won at trial. She was acquitted by a unanimous jury. She got to declare jury. Why go back into court? Well, she says she's seeking justice because she was treated unfairly. She was scapegoated. That could be one part. Maybe she wants some money, which is what she's going after in her civil claims. Or maybe it's partly defensive because she's being sued for wrongful death. Maybe they think on her side that they need to have claims going the other direction. There's a lot of lawyers who think the best defense is a good offense. So there could be all sorts of motivations. What really gets me about this case is we've had 2 trials in criminal court. We're in civil court, and somebody is lying. That is one thing we know about this case. Somebody is lying about being innocent or lying about the extent of what they know. And a lot of you have different views on who that is. Will we see it? Will we find out in the civil proceedings, or will there still be different views on different sides? It remains to be seen. I think the next hearing is December 19th, and I'm going to keep an eye on it here because we're in civil litigation now, and this is a podcast about civil litigation. I really appreciate you watching or listening or whatever. Do the subscribe or the like or don't if you don't want to, but if you do, please do. We'll be back soon with some more insight on civil litigation matters. For now, we are adjourned.